morning, everyone. I'd like to welcome you today for the first in our three-part webinar series on environmental rights. My name is Clodagh Daly and I work with Community Law and Mediation's Centre for Environmental Justice. Many of you will be aware that Community Law and Mediation launched our Centre for Environmental Justice in February of 2021. Environmental justice is about the intersection of social justice and environmentalism, in other words, the protection of both people and planet. And the Centre works to bridge the gap between environmental and social justice, and this includes bringing an environmental lens to social justice issues like substandard housing conditions, energy poverty, poor mental and physical health, and inadequate access to services such as transport or amenities like green space. So ensuring that everyone has awareness of their environmental rights is a critically important aspect of this, and we especially welcome those joining today who are completely new to this area. And we hope that the information provided on the Aarhus Convention might provide new insights in thinking about how environmental and social justice issues can be addressed holistically. And over the course of the three webinars, we'll be answering questions like, why is access to environmental information a critically important right? That's today. What does public participation in environmental decision-making actually mean? And when is it necessary to bring legal cases to protect environmental rights? And who then gets to actually go to court? We're really grateful to the Community Foundation for Ireland for funding this training series, and to Eoin Brady and Niall Sargent, our expert guest speakers here this morning. There will be a space for questions and answers at the end of the session, so please do use the Q&A box at the bottom of your screen for any questions you might have. And if you see a question similar to one that you would like to ask, I'd ask you to please upvote that question with the thumbs up icon. Given that this is a short event, I don't want to take up any more of our time, so I'm going to pass over to our speakers. So we're going to start today with Niall Sargent. Niall is a multimedia investigative reporter with Noteworthy, a community-led investigative journalism platform with a journal. Niall specialises in issues related to climate change, biodiversity, ecosystem services, and food production, and he's worked on various EU cross-border projects with reporters. He was previously editor of the Green News, an online environmental news website, and has research experience with EcoEye, RTÉ's flagship environmental TV show. AIE requests have formed the backbone of research and investigations all throughout Niall's career. So I'll hand over to you, Niall.
Thank you very much, Clodagh. I'm just going to share my screen now, so you might just let me know that you're seeing this.
That's perfect. Yeah, thanks, Niall.
Pleasure. So, perfect. So yeah, look, really happy to be talking at this event this year. It's great to see a good turnout as well for it. So it's a really important issue, I think, is access to information on the environment, access to environmental information, documentation, for the public to be involved in this process, because there's a long history in Ireland of, I think, not necessarily being fully aware of certain decision-making behind projects or activities or government policies, or generally what's going on the scene with authorities around environmental decision-making. And we're catching up on it now. It's getting better. And I think one of the reasons why we're catching up, we're talking with Eoin, Eoin and Clodagh just before we started, is the pressure that's building through all these access to information on the environment requests are in a way forcing authorities to be more transparent with their documentation and the decision-making process. So it's great to see that we're moving in that direction, and really AIE has had a big role. So I'm going to give you a quick overview from the journalistic perspective. One example of how we, in our work, have actually used AIE, access information on the environment requests, in practice, and then a quick guide through of the steps you would normally take to send your own request. So just to give you a quick, like in Noteworthy, we would use AIE requests a lot. This is just an example of 4 investigations we've done on different environmental and climate issues where AIE was used to a large extent, but I think probably I've used AIE requests in maybe 15 investigations. Like, I very, very regularly use them because it's such a great tool to get documentation. People probably know freedom of information requests, FOI requests. AIE is basically its environmental cousin. But it's, in my opinion, it's much stronger, and I think Eoin's going to guide you through some of that later. So I'm just going to show the reason why we have to send AIE requests. Like I said, is this roadblocks for environmental reporting. So there is, in many cases across many departments, agencies, state authorities, a lack of transparency on the decision-making process. There's a lack of publicly available data, research, documentation. I mean, there is a lot of documents on government websites and the EPA's website and other authorities, but there's also a lot that is missing, and a lot that, you know, when you actually send requests, you see the level of documentation behind decisions that are not available to the public and that have made big part in the public decision making process. There's also a reason for using on the restrictive decision making process with FOI requests. So they're very similar in terms of how you make a request and the type of documents you could look for, but FOI requests can be especially more limited for making requests to some semi-state bodies who are either like partially or totally exempt from the FOI legislation. So there's great limits there that you can kind of bypass with the AIE request, because it's excuse me, it's for environmental and climate, but it's a very broad definition that I think Owen's going to sort of give you an overview of later. So one example of where we used it was an investigation on peat extraction in Ireland. So we were looking at large-scale industrial peat extraction without licensing, without planning permission, and in breach of EU law. That was pretty much going on for decades in plain sight. So we wanted to see like what authorities were doing over this time. Why had they failed to tackle it? Not going to go much into this. This is just, you can see this is the tourist image of what we do with peat in Ireland. This is the reality, basically industrial scale mass extraction of peat for horticultural use like this, for burning, for power as well. So it's on an industrial scale and it's been going on for a long time. So the reason in this investigation we needed to send requests, access to information on the environment request, was because there was a real lack of public records. Because these companies are, this is the ironic, sadly ironic part of it, is because these companies are operating without licenses, without planning permission, there's no documentation, there's no monitoring public of them. So there's no data on how much has been extracted, there's no import or export of peat data, there's no planning files, there's no enforcement files publicly because they don't have the licenses of planning. And then if I would just ask a press officer or ask a specialist, they would say, I get these Kafkaesque decision making or these Kafkaesque answers of, well, can you give me a planning file and I'll go look up the documents to see if they're there? And of course, my answer is, well, they don't have planning permission. They're operating illegally. So surely if you have an enforcement file against them for operating illegally, if you've been to the site and inspected it, you would have a record of like, well, we don't know where to start looking unless you give us a planning file number. And it would just be this repetitious cycle of, but we both know they don't have a file number because they don't have the planning permission. But if you have records, you'll know who I'm talking about if I'm giving you specific company names or individual names. So it could have gone around in circles. So basically, I sent a lot of access to information on the environment requests. I think in this case, I sent 71 or 72 in total. So I sent requests to any local authority where there's peat extraction sites that I know were operating, to different state authorities and different departments, semi-state bodies, the Environmental Protection Agency, everyone who has some form of responsibility around peat, and would ask various different questions for like lobbying records from different companies to ministers, briefing documents that went to minister about illegal extraction, any inspection reports by the county councils or an inspection report by the EPA, any internal reports about like the scale of external extraction, any internal data about extraction, like how much had been illegally extracted. So it was a lot of work, but like by sending these requests, we were able to, one, see the reality. Like this was the key thing. We got lots of site inspection reports released to us by the Environmental Protection Agency in relation to activities by particular companies, one of whom has now been, there's a High Court decision against them, or an injunction to stop extraction because the Environmental Protection Agency took them to court. But this is one of their sites. And, you can't access this site it's hidden from the public road, so you can't go on and trespass as a journalist. If you put up a drone, you could film it, but you could also get into some issues there in terms of filming over their site, etc. But what made it fantastic was being able to see this, and this is possible through access to information in the environment, asking the EPA for copies of any site inspection reports, any photos taken during those site inspections, any videos taken during those site inspections. And those are the sort of documents that can be released. And those are the documents that allowed us to show the public this is the reality of what's going on without license, without planning permission across the Midlands in Ireland. And this is another company who's doing similar activities in the Midlands. And these are leading horticultural feed companies in Ireland, and they're being investigated by the Environmental Protection Agency over the course of several years in some cases. But it just shows you the scale of what is being done. And again, same request for that sort of information, inspection reports, warning letters, correspondence with the companies to see, what the companies were saying back to the EPA in their defense, and what the EPA would go back and say, well, actually, what you're saying doesn't stack up because you don't have X permissions. So it really helped us to actually go ahead and do, I think it says 10 part, I think I managed to get 11 in the end. Like, we did a fairly extensive series on this, but the majority of those articles, AIE was absolutely central to telling that story. So for the next 5 or so minutes, I'm going to guide you through sending your own request. It says A to Z, but there's not that many steps here. There could be, but I've limited it to the core ones. And the reason I wanted to show an example first is because sometimes I think people say, oh, you just do A, B, C, D, E, and there you go. You'll get everything. It doesn't work like that. Like, a lot of those requests, of 70 something requests I sent, not all of them gave documents. Like, I would get rejected and refused in some cases, sometimes justifiable reasons, some I would argue against. Sometimes there was big redactions of the documents. Sometimes I only got some documents. Sometimes the documents I wanted, I got, but they actually weren't even that useful in the end. But in, maybe 25 of those 70 requests, I got like smoking gun documents that really helped tell the story. So it's just to show you it does work, but even following these steps, you don't always get what you're looking for. But it's just trial and error, rinse and repeat, and you'll get it. But taking these steps will really help. So I'd say, like, the first step is kind of obvious, but I think people sometimes skip through this. A lot of journalists kind of skip through of like, what do you actually want? Like, what's the key thing? You don't just see something and then jump and say, okay, I'm going to ask for all documents about this issue. You really need to consider what you want, why you really want it. That can be whatever subject it is. Like for peat extraction, for me, I wouldn't just go to the Environmental Protection Agency and go, give me all your documents about illegal peat extraction, because there's probably thousands and you're going to get refused because it's excessive, it's voluminous, it's going to take too much time for them to compile. So you have to really think. So think about the types of what you want, why you want it. Is there particular meetings you think happened or of that you might want to see the minutes of them? Is there briefing papers that, may have gone to a minister about a particular issue? Internal audits, like councils, authorities audits all the time. So you might be concerned about an issue. You might look for the internal audits about that particular issue to see, like, internally, if the department are keeping checks on themselves, if there's any problems. Like for me, in the case of the peat, I knew, okay, how am I going to actually see what's happening on the ground? Surely the state authorities are inspecting these sites. So I look for inspection reports or site inspection reports. And that was a massive help to me. You can also look for stuff like emails, text messages. Like, it's really, the list goes on, but it's really important to consider the types of documents you want and why you want them. Because otherwise, if you're asking just for what you think are you going on a fishing exercise or looking for a treasure trove of information, you're not going to really find what you're looking for. And of course, you can ask for data as well. So really think about what you want. What are you trying to tell with these documents? Who to target? Like, you need to know where your request should go. There's nothing worse than sending a request to the wrong department and then they say, well, we don't have information on that because you sent it to the wrong place. So do your research and figure out who it needs to go to. The public authority, it's very, very broad. under AIE in particular. So you can be sending it to state departments, local authorities like your councils, semi-state bodies. There are a lot of restrictions on semi-state bodies under FOI, not so much under AIE, although there's a lot of issues now with subsidiaries of semi-states, such as Bord Namona. There's a lot of decisions that I would disagree with being made by some semi-states around their own subsidiaries, saying that they're not public authorities, which I think, yeah, the High Court has made a recent decision which kind of says they should be considered. But basically, any state authority, there's a long list of state authorities, pretty much anyone who has involvement holding documents for the state or state body. And important to note as well, you can send the same request for documents. Like you could send the same request to multiple departments or agencies or similar requests. Like in the Pete example, sometimes I sent almost word for word the same request to different departments because I knew they were all part of a working group, for example. And sometimes one department will release some records to you and the other one will release less or more, or some might redact. One department will redact a document and another department won't, because they're all interpreting the AIE regulations in their own way. So it can help to send a same or similar request to multiple departments. You don't just have to limit it to one. So that's kind of the two main steps to take at the start. It's like what sort of documents do you want to look for, and who you're sending to, and then you're sending your request. So it's a pretty straightforward thing. It's basically an email. In principle, you have to give your name and contact details, but for me, you don't need to give I've never give my address or anything. I give my name and my email, and that's enough in my signature. So basically, you just need to provide that. State you're making an AIE request. That's probably the most important thing. It's like some magic phrase that makes it an official AIE request. So I always just say in mine, I say, "Good morning. I wish to make a request under the AIE regulations or under the access to information on the environment regulations for the following." And then I list what I'm looking for. That's the magic phrase. You don't have to quote a long list of legislation and regulation and rules and EU directives. You just need to say that magic phrase and it's an AIE request. You just, like I said, be as specific as possible about what you're looking for. The types of documents, limit the time period. If you go to the Department of Climate and ask them for all their records for all time about climate, you're going to be refused because there's going to be hundreds of thousands, if not millions, of pieces of records. And someone has to go look for those documents. So they have to look for them. They have to check if they can be released. They only have to redact them. So you have to be as limited and possible as what you're asking for and the time period that you're looking for. I always specify the format. I always say, please, return it in an electronic format, because sometimes I've been sent a big pile of documents in the post, which isn't great for the environment either, but it's a pain in the ass to look through because you can't obviously Control F and search, for specific phrases you might want to look for. So I always say electronic, and I always say as soon as possible, but they have 20 days to get back to you. Usually you're going to get your answer by the deadline. It's very rare. Sometimes you do get an answer quite quickly, but it's rare. And I always request an acknowledgement letter. They will have to send you an acknowledgement letter generally, but just stating that shows how the process works and what to expect. And if you don't know the email to send it through, noteworthy, actually, we have a table on our website. I can give the link to Chloe afterwards, where you can go and check. We have all the departments and their emails, but honestly, sometimes even myself, I just Google, say, EPA AIE request, and the first result you click in, and then the email address is right there. They're very straightforward. So once you send a request, then you mark your calendar. So I make a spreadsheet like I showed earlier, this master list, especially when you have multiple requests ongoing with multiple deadlines. You just really need to keep track of it, because before you know it, if you have 5, 10 requests, 20, 30 requests ongoing, you'll lose track very quickly of which one is which. So I always make an Excel spreadsheet, say request sent to Department of Climate Action, the date I sent it. I just count forward 20 days. I put the deadline date. Once I get the acknowledgement letter with a reference, it would be AIE-2023-12. So I put that reference in, that I know if I need to go back to them and say, hey, you missed the deadline on this one, what's going on? Or if I want to quickly check my emails, I can just search for that reference number. It just helps a lot, really, really helps a lot. Um, and yeah, you should get the name of the person handling your request if you need to contact them as well. So just to keep all that noted, everyone does it in different ways, but I think a spreadsheet like Excel spreadsheet or Google Sheets is the easiest way to do it. And follow up, that's really important. Like they have 20 days to answer the request, so you're essentially looking at 4 weeks. But don't just let the 4 weeks go by if you don't hear anything. Like you should get an acknowledgement letter within the first 2 weeks. You should know who the person handling your request is. Um, and if they don't get in touch with you, I'd say within a week, I usually follow up as just a reminder, because it just shows them they may be busy, you never know, but it shows them that you're not just sitting around waiting. Like you're active in this request. You're not just going to wait passively to get a rejection letter after 4 weeks. That you're like following up. Hey, do you need me to refine anything? Is everything clear? And get everything in writing. Sometimes in the past, I've been called and asked to like refine things without real justification. So I always say, okay, please put that all in writing in an email. And very quickly they're like, oh, okay. And then the request just gets processed as normal because they're hoping to talk you out of your request, basically. So just make sure everything, even if you have a good conversation, make sure to say, well, look, I agree to those refinements, but put it in writing in an email back and forth between the authority. Otherwise, things get lost in translation and you might get refused. And you might say, well, you told me it would be fine if I changed it. And they might go, well, no, that's not how I remember that conversation. So get everything in writing. And then when the deadline date comes, this is what should happen. You'll get a letter outlining the decision. So if yes, we release some documents or not, they have to give a justification. If they're not releasing, they have to give a justification under the regulations. Why not? So there's certain reasons why some documents can be refused or redacted, etc. But they have to justify it. And they need to give you a schedule of all the records, whether they release them or not. That's really important because even sometimes the records that don't get released, it's important to even see they exist, if that makes sense. Like sometimes I've had records that were not released to me for public security issues or whatever the justification, but just actually knowing the record existed was important for me in my story because that's even what I was looking for, just confirmation that a particular record existed, whether it was released to me or not. So you'll get a decision letter and a schedule of the records. And like I said at the start, you might get all the records and it's the perfect day and you're super happy, and like me, you get these documents that pretty much are the smoking gun for your story. But sometimes you'll get lots of documents redacted. They can ask for an extra month to process some requests if they're very complex. Sometimes it's the delay, sometimes it's very justified, but you can also be completely refused and not get any records. And also, if you don't get a reply within that 4 week deadline, it could be a genuine delay or it could be what they call a deemed refusal. So if they don't reply to you at the deadline, and this is why it's really good to keep a track on the calendar and you don't miss these things, because you could follow up 2 months later and be like, oh, that request never came through. And they say, well, it was a deemed refusal. We didn't reply, so you should have taken that as we didn't want to give you any of the documents. So it's always good to keep track. And it's really important at that stage, this is the last part, is just you need to examine those reasons they've refused. So has to be justified by reference to the regulations. They can't just say, we're not giving you those documents because, I don't know, it was your request, we didn't like it. They can't just say things like that. They have to justify it with an article or whatever of the regulations stated. It was a voluminous request or there's public safety issues, whatever it is, they have to justify it by reference to the regulations. If you're not happy, you can request an internal review, which basically it just goes to someone higher up the chain to examine your request. And it's no fee under AIE. There's a fee under FOI, but not under AIE. So that's a good one. You don't have to give a justification. You don't have to say, I'm making this internal review because I didn't like your decision, because under the regulate. You just have to say, look, I want an internal review of that decision. That's all. You email them back and say that. And then they get another 20 days for someone more senior within the organization to examine it. Sometimes works, sometimes doesn't. Most often the same decision is made, but sometimes I've got different decisions. And if you're not happy with that process, then you can go to the Office of the Commissioner for Environmental Information. There is a little fee. It's a much more, don't hold your breath. I think Owen will have much more experience on his side, I think, with the going to this stage, and other people. I usually don't, because I don't have the patience for it or the time as a journalist to wait potentially up to 12 months to get an answer. But you can take it to all that stage to the commissioner, and he will make a decision. Decisions are getting better, but like usually you don't need to go to that stage. But look, that's whirlwind overview of like a good example of how it can be really important for journalists, but I think for activism as well, and community organizations can use these sort of requests and a quick step through. But like I said, it's a fairly straightforward process like that. It's essentially sending an email with this magic expression, under the AIE regulations, I wish to ask for the following. And if you're limited, if you've done your research, you're asking for limited set of documentation, a limited time period, you're sending it to the right organization, there's a good chance you're going to get something back to help tell whatever story or whatever project you're working on. So it's a super powerful tool. And if you have any questions at the end, more than happy to answer.
Thank you so much for that, Niall. It was such a practical guide and overview to the AIE requests, and really shows how important it is to the work that you do. Just to add, one of the reasons that we run this webinar series each year is because we run free legal advice clinics, as many here will know, and a lot of queries that present to our clinics, there won't be initially enough information available for us to know whether or not there is a breach of the law. And so often we have to ask clients to go and submit an AIE request. So having this really practical guide to making AIE requests is really, really helpful. And for those who are tuning in, like sometimes making an AIE request for the first time can seem quite daunting, but it is something, as Niall says, that it really can be done by anybody simply by stating that it is an access to information on the environment request, and you do have a right to that information as well. So now to talk us through the case law on AIE requests, we're going to hand over to Eoin Brady. I'd encourage everyone to keep the questions coming. I saw someone asked if this is being recorded, and it is being recorded. It will be available on YouTube after as well. So Eoin is a partner with FP Lowe Solicitors, who specialise in environmental planning, data protection and information law. Previously, Eoin worked for a large commercial firm where he advised public sector clients on AIE, and as a senior solicitor with EirGrid, the national electricity transmission operator, he was responsible for an oversight of a large volume of AIE requests. He previously worked as an environmental lawyer on forestry policy issues with Client Earth in Brussels in Belgium, and he has a master's in environmental law from Queen's University Belfast. So thanks a million, Eoin, for joining us today, and I'm going to hand over to you now.
Thanks, Claudia. Thank you. I was just, as you were reading that out there, I was just thinking I was on the receiving end at one stage of a lot of Niall's AIEs. So it's funny how things turn out. But I suppose at this stage, in terms of our use of AIE, it's very similar in a way to what Niall is doing, because we use AIE to investigate particular issues that are of relevance to our clients. So we're a very small law firm, specializing in environmental planning issues, and really critically, AIE is a core tool of our work. We just simply couldn't do the work that we do without AIE. It's fundamental. So when a client comes to me, or a potential client, or somebody just with an inquiry, probably the first thing I do once I get a sort of general understanding of the issue is to put out AIE requests concerning the issue, because it generally involves some element of a public authority. So I'm just going to this morning step through a bit of, in a very, very high level, just what's involved with the AIE regulations and some key parts of the regulations, sort of where it comes from, and then maybe just stepping then into like some practical examples of that, similar to Niall in a way, and how that can feature in legal cases. And then obviously we'll take some questions then at the end. So I'm just going to share my screen there. Hopefully you can see that. Hold on. Sorry. Can you see that there, Clodagh?
Yeah, that's perfect. Thanks.
Where is it? Okay. So basically, just this is a city called Aarhus in Denmark, and basically, this is kind of where AIE all begins, in my view, because there was a convention of the United Nations Economic Commission for Europe that was agreed in the city of Aarhus in Denmark in the late 1990s, and this convention is the core of the AIE regulations that we have in Ireland. And I'm just going to give you a brief overview of what's involved with the Aarhus Convention. Now, I could, probably a lot of you on the call or on the webinar this morning probably know about the Aarhus Convention, so maybe some of this is familiar to you, but I'm just going to step through it briefly anyway. So the Aarhus Convention, fundamentally, just what it's about is encapsulated there in Article 1 of the Convention. It says, in order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee the rights of access to information, public participation in decision-making, and access to justice in environmental matters in accordance with the provisions of this convention. So, as you can see, there's three elements to it there. There's the right of access to information, there's public participation in decision-making, and access to justice. And this is what we sort of call the three stools of the Aarhus Convention. And at its core, what the Aarhus Convention is this concept of environmental democracy, that people have the right to know what's going on in relation to the environment that they live in, and that in order to do that, there's three different requirements. There's the requirement in the first hand to have access to information. You in order to participate, which is the second leg of the stool, you need to know what's actually happening. And so, that can be as basic as knowing that there's a planning application going on in the area, or that there's a new proposed development that's going to cause emissions into the environment. That the public should be aware of that, and that there's an obligation on the state and its various emanations to put forward that information. And it's only with that information, armed with that information, that people can then properly participate to make submissions and so on, in a process, a planning process, or an environmental consenting process. And then the third and final element of it is this concept of access to justice, or effectively an independent review. So in other words, that again, the state will have its apparatus of its decision-making functions, but that people should have the right to challenge those decisions if they feel that they are not in compliance with law. And so that's a key element. So it's really in a lot of ways about the rule of law. There's a lot of talk about that around Europe at the moment, the tax on the rule of law. But the Aarhus Convention is actually fundamentally about the rule of law in relation to the environment. So it's really important. So again, there's a number of elements to what AIE is. As I said, there's this concept, and Niall spoke about it, this access to environmental information on request. That's obviously a key element in a lot of what we'll deal with today. There also places a set of obligations on public authorities to organise and disseminate environmental information and to progressively use electronic means to do so. That's also really, really important, because in terms of having that real access to information, that basically, like, it shouldn't be on the likes of Niall or myself to be making multiple information requests for fairly routine information. There should be an obligation on public authorities to organise that information as it's being collated within their administrative day-to-day functions, and that basically that regular types of information that is concerning the environment should actively be disseminated. It shouldn't be a case of you having to make a request and every month try and find out what particular volume of pesticides are being used or whatever it might be. That information should be put forward by the public authority and using electronic means, in other words, should be available online, to allow people, no matter where they are, to access that information. That is a problem. There's a, you know, it's not the compliance with that element of the regulations and the convention is problematic. We'll come back to that later. There's then also an obligation on public authorities to make information available where there's an imminent threat to human health or the environment. So that sort of overrides, you know, particular exemption provisions that we'll come to later. And that's a key thing, that that basically, where there is something happening in the here and now that is really, really serious, that basically the public have the right to information about that. So basically, what is environmental information? It's information in any form, written, visual, oral, electronic, etc., on the state of the elements of the environment, be that air, water, soil, land, biological diversity. And then it's factors affecting or likely to affect the elements of the environment, that being substances, energy, noise, emissions, etc. And it also encompasses measures affecting or likely to affect such elements and factors. It includes reports on the implementation of environmental legislation. It includes economic analysis used in the framework of measures. That was one of the ones before. And then it includes information on the state of human health and safety and conditions of human life. So one of the key things, and the definition in some ways is quite complicated, and you know, there's a lot of case law kind of on elements of it, but fundamentally it's really wide ranging. And the case law that we have confirms that. It is a very, very broad definition. So it's something that doesn't have the word environment in it. That does not necessarily mean that it's not environmental information, because of that definition. And that's going back to what Niall was saying at the outset in terms of the difference between maybe freedom of information and AIE, is that when it comes to something that may have an environmental impact, that may be related to the conditions of the environment, that, you know, you are better off using AIE because it is quite broad. And then, as we'll see in a while, the exemptions are more limited in relation to it, and than would be the case with FOI. The AIE regulations apply to what's defined as a public authority, and again, the definition of a public authority is quite broad, and it includes, as Niall said, subsidiary companies of public authorities, and that's something that we see quite a bit now. Is that you know, what would have been our traditional maybe semi-state companies and so on have formed numerous subsidiary companies and so on, or even common ventures with other companies, and those will generally be caught by the definition of public authority. So again, it's very broad, and it's about really the case law is about capturing the full role of the state, because sometimes, particularly lately in the last 20-30 years, the state has has broken up traditional state monopolies and so on into different structures. And it's the case law that's coming from the Court of Justice is about capturing those new types of structures, that it's still effectively the state controlling these entities, these corporate entities, and therefore they're caught by the definition of public authority. So there's again, as I said, there's this duty to disseminate information. It's in Article 5, and that includes that basically an obligation to train their staff, the staff of public authorities, in the use of AIE, because effectively, it's no good if there's these regulations unless the staff in them are trained in AIE and also made aware of how important, and these are legal obligations. They can't be ignored or downplayed. And part of that then again is a duty to assist applicants in relation to an AIE request. And the likes of Niall or maybe myself, that do a lot of these, we sort of know the ropes. But if you're coming at it for the first time, you mightn't know exactly what to look for, as Niall pointed out earlier. You might be unsure of something. You maybe framed the request initially as too broad, and so on, or just not clear to the other side, the public authority. Basically, they have a duty to try and engage with you, to try and make the request manageable and understandable. They can't just say, sorry, no, that's too much, or we're just not going to engage with that. That's not actually allowed under the regulations. And again, as I was saying, this wide concept of what environmental information is, there's been a good bit of case law on that here in Ireland over the last while, and that is basically now it's confirmed, at the highest court level, that we have this really broad definition of environmental information. And again, regulations do not apply to information that is otherwise required to be made available to the public. So again, like if this is going back to this dissemination that I was saying, if a public authority has done the right thing and basically has put the information up online on their website as they're supposed to do, then you're not entitled then to go and make individual requests for that information, because they've actually done the right thing and it's up there already. There's restrictions then and as I said earlier, there are exemptions to the rights of access to information, but they are more limited than under the Freedom of Information Act. And where basically you can show that there's an adverse effect on personal information, material supplied by a third party that was not under an obligation to agree release, where there's an adverse effect actually on the protection of the environment itself, or on the confidentiality of the proceedings of public authorities, then information may be refused in those circumstances. Again, another exemption is for discussions at meetings of the government, and again, adverse effects not required in that example. Again, other exemptions are where there's an adverse effect on international relations, national defense, or public security, where it's information that's in the course of justice, commercial or industrial confidentiality, or intellectual property rights. Again, you can be refused information on those bases. There's then what we call administrative grounds for refusal. That is where material that's in the course of completion, that's basically where there's an internal process and it hasn't been fully worked out. And then another example there is where there's internal communications of public bodies, or where it's manifestly unreasonable or too general in nature. And again, let's come back to this duty to assist. So as Niall said, it's very important, as he said at the outset, to think about what it is that you want, and not to like ask for everything under the sun, because that generally will result in a refusal. It'll delay you, it'll frustrate you, and also, in my experience, it's you want to the people at the other end of an AIE request, and obviously I was in that boat myself at one stage, they're just doing a job as well. They have their job to do, and most of them realize their obligations under regulations. So you have to sort of work with them and assist them to do their job. And then in most of the cases, they will actually do their job and they'll do it properly. But you have to just be reasonable in terms of what you're looking for, and that they're not effectively overloaded by it, So again, there's a clawback on these exemptions. So where those exemptions relate to what we call emissions into the environment, that then de-exempts effectively the exemption, and that information then has to be supplied. And so again, it's about that core element, or the behind the Aarhus Convention and the regulations, is about protection of the environment effectively, so that the where there's actually real emissions in that are related to the information, that overrides the sort of exemptions that might be applied, say, for commercial or industrial confidentiality. One of the things about the exemptions then as well, and this is a key element to it, is that effectively you have to apply what we call the public interest test. So yes, there might be industrial or commercial confidentiality in relation to in relation to the data. So, for example, like I have requests into on board BIA for information on, say, the Origin Green scheme to do with the sort of standards for the agricultural agri-food industry, you know, and I've been refused those on the basis of commercial confidentiality, that this is, you know, this is the private information of the companies involved. And I would be saying in response to that, well, actually, that the public interest trumps that, because the public are ultimately paying, you know, paying Borbia as a state agency. This is public monies that are being invested. We are promoting this, you know, brand across the world. So therefore, the Irish public should know what are the standards, what is the auditing of this scheme that has been applied. So that one's one to be determined. But it just gives you an example, or give you an indication of, you know, so that yes, there is a commercial confidentiality element to that particular request, but there is a public interest that I would say overrides that private interest of the particular companies involved. This is another key element to the regulations: a presumption in favor of disclosure. It's not a presumption that basically that the public authority can withhold the information. There's a presumption that the public are entitled to all environmental information. And that means then that the exemptions have to be treated in that sort of restrictive sense. You actually have to show the harm. It's not sufficient to say, oh, you know, if this and such a thing happens, that potentially, you know, way off down the line there might be some harm. You actually have to show where is the harm here and now from release of information to the public. And in relation to that as well, and part of that is that basically the public authority would be obliged to, if there is an exemption that may be legitimately applied, it doesn't have to be applied to the whole entirety of the information, only the part of the information where that harm would arise from. The rest of the information has to be released, and that's a key thing. And in practice, it's not applied. I have to say, you know, often the public authority will say, "Oh, look, this is commercially confidential in relation to the entire information," and then we have to maybe go and appeal that and so on. There's basically, if the information is not complete, they have to tell you when it is going to be complete, so you can kind of get that information. So it's not good enough to say, "Oh, we're going to make a decision on this at some point in the future." They have to tell you exactly when that decision will be made and then release that information. And then there's provision that basically for deemed refusals, if they haven't come back to you, that it's treated as if it's been refused, and then that allows you then to appeal the refusal to the Information Commissioner. The AIE regulations, as I said, it's like a lot of EU law, and it's designed to be interpreted purposely. And AIE is designed to contribute to a greater awareness, a free exchange of views, and more effective participation in decision making, and eventually to a better environment. And again, that's the first element of the stool, as I spoke to you about, basically access to information. You mightn't do anything with that information, but you may do. But you definitely won't do anything to protect the environment unless you have the access to the information in the first place. That's critical. As I say, it's a broad right of access, but it's not unlimited. The limited number of exemptions, as I said, are to be interpreted restrictively. And even where the exception is engaged, again, the public interest favouring release must be considered. And then, as I said, exempt information is to be separated, and the partial release of that information that's not subject to the exemption. And each piece of information is to be considered individually. And again, as I said, the overriding public interest where it's relating to emissions into the environment. So there's been, as I say, a good bit of case law on the AIE regulations, particularly over the past number of years. There's a client of our firm that we do a lot of work with called Right to Know, and they are a group effectively of investigative journalists and also just concerned citizens that really have spearheaded the implementation of the AIE regulations, and they've done that through effectively, in the first instance, taking AIE requests, really kind of strategically focused the AIE request, and then following that up then with taking cases to the courts, and they've often been very successful. And it's just I have a quote from one of the cases, which was to do with the Taoiseach's office, and the judge said the fact of the matter is that the directive and the AIE regulations provide for a fundamental right of access to environmental information. So just showing what the judiciary had to say. And then again, any decision on a request for environmental information must reflect the fact that the process of engagement with the request, whatever the ultimate outcome, was conducted in accordance with the letter and spirit of the directive. That's really important. And it goes back to what I was saying, this whole, what I was saying about, having to engage with the requester, and having to cooperate, that basically the process of dealing with a request must be compliant with the regulations. And this goes back to the fundamental concept that there's a presumption in favor of release of information. And again, my experience dealing with public authorities, but working for them, and the other side of it, a lot of it is cultural. A lot of our bigger agencies began life, shortly after the creation of the state. They would have done, many good things, back in the day and so on. But the culture, the organization will generate its own culture, and often that then is resistant to transparency. They see themselves as they've got their mission goal, and that is about delivering whatever that mission is, and that providing information to the public is prejudicial, as they would see it, to delivery of that mission. So a lot of the time they've been successful in lobbying the government to have themselves excluded from the Freedom of Information Act. And that to me is a key problem, because in my view and experience, that organizations that are under the FOI Act have a culturally different approach to transparency than those that are outside of it. And the AIE regulations have filled that space of FOI, but in a lot of cases of public authorities that we see, particularly ones that have large-scale environmental functions, there still is this residual sort of hostility, or just maybe hostility is too hard a word, but just that there isn't this culture of transparency with regards to AIE. And it's a matter of sort of kind of continuing on, and slowly but surely things change, and we see that, and as Niall was saying earlier, we've seen that with organizations that slowly, incrementally, as these AIE requests are coming in and being built up, that there is cultural change within organizations. So just in terms of practice, just to give you some practical examples of where AIE has been useful in my work, I wanted to give one example of a case that we dealt with maybe 2 years ago now. It was down in County Roscommon. It was to do with a turlock that had flooded. There was quite bad flooding. It was coming into people's houses and had been ongoing for quite a while. And basically, in order to alleviate this flooding, Roscommon County Council, in conjunction with the Office of Public Works, the OPW, decided that they were going to basically build a pipeline from this particular lake to Lough Ree, which is a distance of about 4 kilometers. So that's the photograph there is just showing the beginning of this pipeline work. But the key thing was this, that there was no planning permission at all for this pipeline, and it was the abstracting water from this turlock, which is a sort of a lake that where the level rises and falls kind of seasonally, but hadn't fallen much in this particular case. But the lake itself was a priority Natura 2000 habitat under the habitats regulation. So it's the highest status of habitat because of the particular plant species that lived on the lake and were reliant on this sort of fluctuating water levels. And the legal position is that you can't, you basically can't get planning permission for works that engage or that would have an adverse impact on one of these Natura 2000 sites without conducting what's called an appropriate assessment under the Habitats Directive. And this hadn't been done in this case. It was sort of seen as an emergency work by the local authority to deal with flooding. And perhaps we see this sort of clash between, I suppose the way that, we see this across Europe, where there's a sort of a clash as we see increasing climate change impacts versus protection of biodiversity and nature. That's, I suppose, for another day. But this was a sort of an example of this closer to home. So basically, when this came in August, I think it was August 2011. I think it was the bank holiday weekend when we got instructed on this, and basically, it was, we were told this is a serious issue by our client. We needed to move on it quickly. So that weekend, I fired out a lot of or a couple of AIE requests. So I sent them to Roscommon County Council, National Parks and Wildlife, Office of Public Works, and the Geological Survey of Ireland. And just as Niall was saying earlier, effectively the requests were more or less identical, just changing like who it was to and so on. Because I knew that these particular, or these four state authorities were involved in the issue. And so it was a sort of an attempt to see what was going on in relation to the same issue. So I got four different, let's say, responses back, and that was quite interesting of its own on its own right. So again, basically, just what happened was that we got some information under AIE. One of the things was that the works had been authorized on the basis that there was an imminent risk to human life. So I used that provision that I spoke about earlier, that where there's an imminent threat to human life, that information has to be released. And a certain amount of information was released initially, which gave me because this had been done outside of planning, none of this information was publicly available. You couldn't get on a website and look at it, for example. So I got this initial amount of information from under the AIE regulations, and that was enough for us to go in for an injunction application into the High Court. And it was during the vacation because the courts were on holidays, and we got that injunction on the 25th of August. And then basically the injunction provided that the pipeline that was in place at that time had to be capped at either end, effectively concrete poured into it and left in situ. It was basically to be refilled in, like earth put back on top of it, because we thought that to take the pipeline out would be more harmful to the environment than just leaving it sit where it was and finishing up and leaving it there. And the council agreed to that. There was an order made in the court to that effect. But then it transpired, and we didn't know about this until it happened, but that works began then, I think it was on the 14th of October, that the council decided they were going to go ahead and go at it again. So basically, I put out straight away that day, I put out a number of AIE requests to Roscommon County Council and so on, to find out about this, because again, we had just literally found out about it. And what transpired, I suppose, was that when I got the information back, I was able to see that on the day of the court order back on the 25th of August, that Roscommon County Council were, within an hour or two of the actual court decision being made, were then planning how they were going to continue with the works. So that was information to me that, look, they weren't happy to abide by the court order as such, and we're going to go forward with something else. And again, basically, I was able to get information back from the National Parks and Wildlife. So again, information that it wasn't given by Roscommon County Council, I was able to get that from the National Parks and Wildlife, that was able to show that basically there'd been a whole course of interaction, again, behind the scenes, that nobody would have known about between Roscommon County Council and the National Parks and Wildlife way back months previously in relation to these works, where they were told effectively that you need to do all these environmental assessments and it's going to take some time. And that was kind of critical in understanding that this wasn't like an emergency as the council were putting it out, because that this was where there was an imminent threat to human life. there wasn't effectively at the time that they decided to undertake the works, because the thing was that under EU law, there is a right to basically disregard environmental assessments where there is an emergency. But an emergency in relation to flooding, and there's guidelines on this, is where there's literally the water is coming at you. Like you wake up in the morning and there's literally the flood coming in the door. Under those circumstances, under EU law, you can take whatever measures effectively to try and protect life and property. But if you know that there's recurrent flooding in an area, it's a longer drawn out process, basically you're obliged to conduct the environmental assessments. So again, I use the example that, you know, was it 2 or 3 years ago in Belgium and Germany, there was really bad flooding in the summer, and basically in those circumstances, people are entitled to take measures, but not where there's recurring flooding over a number of years. At that point, you have to do the proper exercises. So a lot of this case concerned.
Sorry, I'm actually going to have to interrupt you. I'm so sorry.
No worries.
We're just at 11 o'clock now.
Okay.
There's just one other question that has come in that I think would be interesting to hear from you both on. So Sarah Cullen has asked, which organisations or departments have you found to be more likely to respond to requests, and which have been less likely? And I think, Eoin, you know, you spoke about the kind of culture of different public bodies and authorities. Do you have any thoughts on which are more likely to respond to those types of requests?
Yeah, that like, it's a good question, and that goes back to what I was just saying there. I think that, and I'd be interested to hear what Niall has to say, but my experience, those public authorities that are subject to FOI are generally more responsive and have a better attitude to dealing with AIE, because what I consider is that at a board level, at a sort of a corporate, you know, management level within public authorities, that freedom of information is sort of understood more. It's more embedded, and there's sort of a bit more respect for it, I think. The same doesn't apply in those organizations to AIE, access to information and environment. So my experience is that the sort of worst transgressors are those organizations that are outside of the FOI Act. And really, I think many of our public authorities that are either exempt or partially exempt from the FOI Act should be brought in under the FOI Act.
Thanks so much, Eoin. Niall, do you have any thoughts on that one?
Yeah, I think I'd probably have fairly similar findings to that in terms of if they're under FOI, like generally several departments, etc., like there's a better understanding and handling. I find the Environmental Protection Agency are very good to work with and quite transparent in their process. Like I always find them following up quite regularly with me, and will often try to work with me to, you know, if I need to rephrase or refine requests, they'll try to help me with the wording or tell me, look, we think you're looking for this, but it's actually now renamed, or it's probably in a different area, or your request for you, like, we understand that it looks like it's a small request, but actually there's hundreds of little bits of documents or data, and you try to work around, okay, how can we resolve this? That, like, it's not too onerous for you, but I still get what I'm looking for. So they're quite good. But yeah, I think like it's well documented.
Yeah.
That right to know, and also myself and others have had a lot of problems with Board Namona and their decision, and the ESB, but particularly Board Namona lately, in their decision making now around, for some reason, if records are held by subsidiaries of Board Namona, like they have multiple subsidiaries 100% owned with them, same email addresses, same address, like, and 5 years ago, 6 years ago, they would have answered those requests, but now they're saying that all the records are held by subsidiaries who have determined that they're not actually public authorities under the AIE regulations. Now, we put an article about this a while ago. It's been well documented. The High Court ruling that pretty much is saying, like, you know, I think they tried to appeal or whatever, but it's basically saying, look, that decision making process is inaccurate or is incorrect. But now they're still finding different ways of arguing that the record. I had a recent one refused, even though I quoted the High Court case, the Information Commissioner's answer. They've kind of found another way of answering the same thing. So it's well documented. There's a lot of issues there. So I just don't know how it's fully going to be resolved. It has to be through the legal system, unfortunately, and it takes a lot of time because I don't see them changing now. So they've been the biggest problem for me in my requests.
Well, I think I speak for us all when I say that we're very grateful to the work that you both do in accessing really vital environmental information. I'd also just like to thank both Niall and Eoin for their time and expertise today. And I'm sorry that we didn't have more time because I feel like we could spend a whole morning discussing this issue, and there's so much in this. Just to close today's event, I want to remind everyone that this is the first of a 3-part series. Next week's webinar will focus on public participation. That will be on Thursday, October 19th from 10 to 11 a.m. And then the final webinar will be the following Thursday, the 27th, and that will focus on access to justice. The last thing I want to say is that Community Law and Mediation have just published a community guide to the Aarhus Convention. It explains access to information on the environment and also provides a sample guide on how you can make an AIE request. That's available on our website. I've just put a link in the chat box, so please do use that. Thank you so much to Eoin and Niall, and thank you so much to the audience for tuning in today and for your really engaging questions. Thanks, everyone. Bye.
Thanks, Lola. Thanks, everybody.